picture this, right? You just spent 2 years and maybe $40 million on a feature film.
Oh, wow. High stakes.
Yes, super high stakes. You fought to assemble this incredible cast. Your crew just bled for the project. And, well, the final cut is stunning.
Right.
So you hand that final cut over to your distributor, pop the champagne, and go to sleep. But then, and this is the terrifying part, at 6 a.m., your distribution lawyer calls you in an absolute panic.
I can already guess where this is going.
You probably can. The lawyer says, 8 scenes in this movie don't legally belong to you.
Yep. Nightmare material right there.
Like the crowd you filled in for the stadium scene using an AI tool, or that alternate language voiceover, even the de-aged actor in the flashback, none of those hold copyright protection.
And the streaming platform wants them entirely removed before release.
Exactly. It sounds like a total horror story, but that exact scenario is, playing out right now in Burbank, Atlanta, London, basically everywhere content is being made.
It really is. Welcome to Hollywood in 2026, man.
Yeah.
The legal and business landscape around artificial intelligence and entertainment is just moving at light speed right now.
It's hard to even keep up, honestly.
Oh, absolutely. I mean, we are talking about billion-dollar training data lawsuits, the aftermath of historic union strikes, and these new global regulations that seem to arrive almost weekly. The stakes are just incredibly high.
And that is exactly our mission for this deep dive today. We are taking a comprehensive look at Mitch Jackson's 2026 playbook. It's called How to Survive Artificial Intelligence in Hollywood.
Such a crucial read right now.
It really is. And by distilling the key takeaways from, well, all 20 chapters of this massive guide, the goal is to give you, the listener, a positive, functional framework.
Because AI isn't here to just replace human creativity.
No, exactly. The rules being written right now, they exist entirely to protect human artists and their livelihoods. And if you understand them, you can actually use these tools to, scale up your vision without losing your copyrights or, violating union rules or blowing up your distribution deals.
And the path forward is actually incredibly clear once you look at the underlying architecture of these new laws.
Right.
And that architecture, it starts with the most fundamental building block of the entire entertainment business, which is owning the intellectual property.
Yeah, because before a production can even hire a single actor or, lay a single cable, it has to own the underlying work.
Exactly.
So, okay, let's unpack this a bit. What actually happens to a copyright when an AI tool enters the creative process? Because I know the U.S. Copyright Office has this golden rule, and it's pretty stark.
Oh, it is. The rule is basically no human author, no copyright.
Right. It's a hard line in the sand.
Yeah, and it has been for over a century. I mean, think about it. A tool does not write a screenplay. A camera doesn't direct a performance. And a computer doesn't paint a portrait.
The tool stays the tool.
Exactly. So pure machine output from an AI is just not copyrightable in the United States.
See, I always think of using generative AI like ordering a custom cake.
Okay, I like that analogy.
Right. Like if I give a baker an incredibly detailed list of instructions for a cake, the flavors, the specific colors, fondant dragons on top, I still didn't physically bake the cake. The AI is the baker.
Right, you're the client, not the chef.
Exactly. But let me push back here on behalf of the creators listening. What if I write a 1,000-word prompt? I mean, that takes real creative effort, right? Trial and error, iteration. I am describing exactly what I want. Why doesn't that count as authorship?
It's a great question. But, well, because no matter how detailed your 1,000-word prompt is, the AI's algorithm is still making millions of micro decisions.
Ah, I see.
Yeah, decisions about lighting, pixel placement, shadow things you didn't actively dictate. The Copyright Office views prompting as merely instruction, not expressive control. You didn't hold the brush, you just commissioned the painting.
Gotcha.
A really perfect example of this in the playbook is the Teatro d'Opera spatial case.
Oh, I remember this one.
Yeah, the creator won an art competition using an AI image generator. And he submitted, get this, 624 individual text prompts to get the final image.
Wait, really? 624 prompts?
624. But the Copyright Office still denied the registration.
Wow. Even with all that effort.
Yeah, because he didn't physically control the final expression of the pixels.
Okay, so 624 prompts get you nowhere. Is there literally any way for a human to legally own an image or a video that started with an AI generation?
Yes. Thankfully, yes. There is a landmark case commonly referred to as a single piece of American cheese registration. It is, but it's the ultimate playbook for producers right now.
Yeah.
So the creator generated an initial image from a text prompt, but he didn't stop there. He used a technique called in-painting.
Okay, what does that actually mean in practice, like for an editor?
It basically means he brought the AI output into an editing software and physically drove the changes himself.
No, okay.
Yeah, through 35 iterative, step-by-step human modifications. So manually selecting a shadow and changing its gradient, reshaping facial features, erasing elements, and you painting in new ones, he literally transformed the work.
So he was acting more like a digital painter.
Exactly. And the crucial part, he submitted the before and after files documenting every single human stroke, and he earned a copyright registration.
Wow.
Yeah, he proved human authorship through the selection, arrangement, and creative modification of that raw AI output.
That is fascinating. So it's basically about proving you drove the car, not just that you told the car where to go.
That's a perfect way to put it.
Yeah. So producers who actively document their human creative modifications and, just tell the truth on their registration forms, they can successfully defend their chain of title.
Yes, absolutely.
But what about the AI model itself? Like, where it learned to bake that cake in the first place? I'm talking about the training data.
Oh boy. This is where the financial risk gets really staggering. The playbook highlights the Bartz v. Anthropic settlement.
Right.
That one hit $1.5 billion.
It's a billion with a B.
With a B. It revolved around pirated books that were used as training data. The courts are increasingly viewing the use of pirated materials to train an AI as inherently infringing. And that's regardless of how transformative or different the downstream AI output actually looks.
But wait, if I'm a producer, I don't code the AI. I'm just, buying a license to use a commercial tool off the shelf. How am I supposed to know if the vendor used pirated books or stolen images to train their model?
You don't, which is why you have to demand vendor indemnification.
Vendor indemnification, okay.
Yeah. It means you force the AI company to sign a contract stating their training data is completely clean. And if anyone sues your production because of the AI's training data, the vendor pays the legal bills.
Oh, that makes sense. You shift the risk back to them.
Exactly. And if an AI vendor refuses to offer that written indemnification, you simply cannot use their tool on a professional production. Full stop. It's too risky.
Okay, so we've solved the issue of owning the final video file and making sure the tool itself is legally safe to use. But what happens if the face inside that video file belongs to an actor who never actually agreed to be in your movie?
Yeah, that's where the legal framework has to shift from protecting the art to protecting the artist.
Securing the work is only step one. The immediate next hurdle is securing the actual humans inside that work.
Right, and the Screen Actors Guild, SAG-AFTRA, they built a massive framework around this during their historic strikes. It all boils down to the 3 C's.
Consent, compensation, and control.
You got it.
So how does that actually apply to scanning an actor? Say we're doing an action movie. We want to do a dangerous stunt. So we need a digital version of our lead actor to take the fall.
There are 2 main categories you need to know here. First, there's the employment-based digital replica, or EBDR.
EBDR, okay.
This is when you hire an actor for your specific film, you scan their face and body while they're on your payroll, and you build a model strictly for that single project.
Got it, like a one-off digital double. And the second type?
The second is the independently created digital replica,
right,
or ICDR. This is when a model is trained on an actor's past performances or existing footage, rather than a fresh, on-set scan.
That sounds a bit more complicated.
It is. Licensing an independently created digital replica is less like renting an actor's time and more like renting the molds to a factory. You can print out as many performances as you want from that mold, but the union strictly controls how many hours the factory is allowed to run and what kind of products it can even make.
Right. So let me ask you this. What does this mean for a really chaotic set? Let's say we're deep in post-production. It's like 2 a.m., we're totally over budget, and the lead actor mumbled a crucial line of dialogue.
Oh, it happens all the time.
Exactly. And we don't have the time or the money to fly them back out to the recording booth. Can I just, clone their voice with an AI tool, type in the new line, and sneak it into the sound mix to save a buck?
Doing that without explicit negotiated consent is an absolute recipe for a massive lawsuit.
I figured.
State laws are cracking down on this aggressively. Tennessee, for example, passed the ELVIS Act, which specifically targets unauthorized voice cloning. They made it a civil tort, often with criminal penalties attached.
Wait, let's define civil tort for the indie filmmakers listening. What does that actually mean for their bank account?
It means the actor doesn't just send a polite cease and desist letter. They can sue you directly for massive financial damages, compensatory and punitive.
Oh, wow.
Yeah, we are talking about the kind of lawsuit that bankrupts a production company. Your voice is protected by your right of publicity. And that applies even if the AI didn't use a direct audio sample of you, but merely learned to simulate the cadence and tone of your voice.
And I imagine it goes beyond living actors, too. What happens when a legendary actor passes away? Because Hollywood has a really long history of trying to bring deceased icons back to the screen.
Yeah, the rules absolutely extend beyond the grave, but they vary wildly depending on the state where the performer was legally domiciled at their time of death.
Really, it changes by state.
Oh, yeah. California, for instance, passed strict laws granting 70 years of posthumous protection for digital replicas.
Okay, 70 years is a long time.
And then New York recently passed legislation that completely strips out disclaimer exemptions.
Wait, what exactly is a disclaimer exemption?
So, in the past, a producer might use a deceased actor's likeness and just slap a label on the end credits saying, "This is an unauthorized AI replica."
Like a get-out-of-jail-free card.
Exactly, claiming it was a parody or an artistic expression to avoid liability. Well, New York closed that loophole. You cannot just use a label to avoid a lawsuit anymore. You need explicit, negotiated consent from the actor's estate.
Which makes sense.
It does. Treating talent with respect, living or deceased, by drafting clear, specific consent language. That's what creates a clean, defensible asset that distributors will actually love.
But here's where it gets really interesting and frankly incredibly complex for the producer. If my film is going straight to a global streaming platform, meaning it's reaching audiences in all 50 US states and the European Union at the exact same second, how on earth do I comply with 50 different state laws and the EU at the same time?
I know, it sounds impossible. But the strategy is actually straightforward. You build your compliance to the absolute strictest standard on the map.
Okay, aim for the highest bar.
Right. Plus, there is a proposed federal law called the ELVIS Act, which aims to set a national 10-year cap on replica licensing.
What happens if someone violates that?
The law proposes a DMCA-style notice and takedown system across the entire U.S.
Now, for anyone who hasn't dealt with, like, YouTube copyright strikes, what is a DMCA-style takedown?
It stands for the Digital Millennium Copyright Act.
Okay.
It essentially means that if an actor sees an unauthorized AI replica of themselves in your movie, they don't have to take you to court and wait 2 years for a judge to do something.
Oh, nice.
Yeah, they just send a single notice to this streaming platform. And the platform is legally obligated to pull your movie down immediately to avoid being sued themselves. No trial needed.
That is absolutely terrifying for a distributor.
Which is exactly why disclosure laws have become the new gold standard. Places like California and the European Union have both passed massive transparency laws that are going into effect. You have to tell the platforms and the audience exactly when and how artificial intelligence touched your project.
But practically speaking, how do you even track that? A movie has thousands of visual effects shots. How do you prove to the European Union which specific pixels were AI generated and which weren't?
You use the C2PA standard, which stands for Content Credentials.
C2PA. Okay.
Think of it as a cryptographic watermark that's woven directly into the digital DNA of the file itself.
Whoa.
Yeah. From the very moment the light hits the camera sensor, it signs the file. When it goes to the editing software, it records exactly which human editor used which AI tool, and it signs it again. It even survives compression and formatting.
That is brilliant.
It really is.
Yeah.
By embedding C2PA directly into your post-production pipeline, disclosure just becomes an automatic digital audit trail rather than a manual paperwork nightmare.
It's basically a permanent receipt of human authorship attached to the video file. Okay, so we've navigated the legal patchwork, the copyright, the metadata. Let's bring this back down to the actual humans making the movie on set.
Good idea.
The writers, the background actors, the crew.
Right. This is where the labor reality meets the technology. The Writers Guild of America secured specific protections ensuring AI cannot be credited as a writer. But the most vital piece there is protecting what the industry calls separated rights.
Wait, for those outside the Writers Guild, what exactly are separated rights?
Sure. When you write an original screenplay, you don't just own the movie script. You own the right to turn that story into a Broadway play or a novel or a sequel down the line. Those are your separated rights.
Got it.
The union secured an agreement that a studio cannot use a chatbot-generated draft to strip a human writer of those rights. If a studio hands you an AI draft and tells you to, quote, rewrite it, they still have to pay you and credit you as the original first draft human writer.
That is a huge protection. And what about background actors? Because I remember them being a massive sticking point during the strikes. The studios wanted to scam them once for like a couple $100 and just use them forever.
Yeah, that was a huge fight. The union secured strict protections against displacement. So a production cannot use digital replicas to avoid hiring the required minimum number of human background actors for a given scene.
That's great.
And furthermore, when you do scan them for a crowd multiplication effect, you have to navigate incredibly strict biometric privacy laws because you are capturing their actual physical geometry.
Right, their literal faces.
Exactly. States like Illinois have biometric laws where mishandling that data, like failing to delete it after the production ends, can result in devastating fines, like bankrupt your company fines.
Let me challenge this from a studio's perspective, though, specifically regarding the below-the-line crew. If an AI tool can clean up an audio track in 10 seconds instead of 10 hours, isn't the studio just going to fire the sound editor? I mean, why pay a human for a 10-second job?
I get that fear. But if we connect this to the bigger picture, the unions haven't banned AI. They've built a highly regulated permission structure to use it ethically. For IATSE crew members, the contracts now include kit rental fees for AI.
Kit rental fees, what does that mean?
Well, think about a director of photography who owns a really highly specialized, expensive camera.
Like an ARRI Alexa.
Exactly. They don't just get paid their hourly rate. The studio actually pays them a rental fee to use their personal camera on set.
Oh, right.
The same exact concept now applies to software. If an editor or sound designer brings their own licensed, vetted AI tool to work, they negotiate a rental fee for that tool.
Oh, that's so smart.
Keeps the human craft central. The studio isn't firing the sound editor. They are hiring a highly skilled sound editor who operates AI to deliver a pristine track in record time. It ensures human artistry scales up rather than disappears.
I love that framing. It treats the AI as an instrument, not a replacement. Okay, so we've shot the movie, the crew has used their tools brilliantly, and now we are deep in post-production. And this is where the playbook dives into something pretty wild. Synthetic performers. We are talking about wholly AI-generated people.
Yes, like Tilly Norwood.
Right.
She made massive headlines as a completely synthetic AI-generated character who was actually signed by a real talent agency. This creates a really unique legal gap. Since Tilly isn't a real person, right, of publicity laws and posthumous rights just don't apply to her.
But if a synthetic performer isn't a real human, why does the playbook say I still have to pay union fees for it?
Because of what the industry calls the Tilly tax.
The Tilly tax.
Yep. In commercial contracts, using a wholly synthetic performer triggers union compensation because that algorithm occupies a slot that a human actor would have filled.
Oh, that makes total sense.
Yeah, it's a deliberate mechanism to protect the human labor pool from just being wholesale replaced by cheap algorithms.
And we also have to draw a hard line between these completely fake people and digital alterations of real people, right? Because they aren't the same thing.
A crucial distinction. A digital replica creates a performance the actor never actually gave. But a digital alteration changes a performance the actor did give on set.
Like what?
Think of polishing an actor's accent in post-production, or de-aging them for a flashback. If you change the fundamental character of a performance materially, it isn't just a routine visual effects note anymore. It triggers consent rules, state laws, and those C2PA disclosure requirements we talked about.
Man. And while you're rendering all these visual effects, you can apparently fall into what the book calls trademark traps.
Oh, these are dangerous.
Like, imagine you are an indie director, you type a prompt for a cool background cityscape, and the AI just hallucinates Spider-Man swinging in the background.
This is a major issue. The AI tool might not even warn you, but suddenly you have a massive Marvel infringement sitting right there in your movie.
Yikes.
But it's not just copyright. It actually leads to false endorsement claims under trademark law. The studio can argue that the audience will falsely believe Marvel endorsed your film.
Just because Spider-Man is in the background.
Exactly. You have to log your prompts, and you have to use negative prompts, literally telling the AI specifically not to generate protected IP or famous logos.
Wow. So the movie is finally done, it's clean, and the marketing team takes over. And they decide, hey, let's use AI to generate a cool movie poster.
And they step into a totally different legal arena. The playbook emphasizes that trailers and posters do not have the same First Amendment expressive work shields as the movie itself.
Wait, can you explain that distinction? That sounds important.
It is. The movie itself is considered art.
Yeah.
It is protected by free speech, which gives it wide latitude for parody, commentary, and artistic expression.
Okay.
But a movie poster or a commercial, That is classified as commercial speech. It exists solely to sell a product. And commercial speech has far fewer First Amendment protections. So an AI-generated element that might be perfectly legal as protected art inside the film could trigger a massive lawsuit if you put it on a billboard to sell tickets.
That is wild. So after surviving the Copyright Office, the state laws, the unions, and the marketing traps, how do we actually prove to the distributor that we did everything right?
It all comes down to the AI writer in your contracts. A standard agreement just isn't enough anymore. You need specific legal writers that dictate exactly what can and cannot be done with AI on your set.
Right.
And this directly feeds into your errors and omissions insurance, your E&O. Underwriters are demanding rigorous chain of title checklists now. They want the vendor indemnifications, the C2PA metadata logs, and the talent consent forms. All of it.
Which proves the central thesis of all 20 chapters, really. AI in entertainment runs on documentation. If you can't prove how you made it, you don't own it.
Exactly. That paperwork is what gets a project past the distributor's lawyers, past the insurance underwriters, and finally out to the audience.
It is honestly a staggering amount of information to process.
It is.
But looking at it from a high level, it actually leaves me feeling incredibly positive. Because knowing these rules is the ultimate superpower for a modern creator. You don't have to be afraid of AI. You just have to know how to drive the car and, keep the receipts.
Knowledge of the framework is truly the greatest asset you can bring to a production today.
But I have to admit, doing this all by hand, if you're an indie filmmaker listening to this right now, you're probably thinking, I don't have a massive team of lawyers to track metadata and draft biometric consent forms.
Oh, for sure.
Like drafting compliance writers for 50 different states, filling out E&O questionnaires. It sounds exhausting.
Which is exactly why Mitch Jackson and his team didn't just stop at writing a book. They're actually building a brand new AI software platform specifically to solve this exact bottleneck.
Oh, that's amazing.
Yeah, doing it manually is exhausting.
Yeah.
So this new platform is designed to take in a project's specific parameters, like your cast, your locations, the specific AI tools you're using, and it instantly generates the compliant AI writers, the chain of title questionnaires, the C2PA checklists, and the E&O underwriter packages.
So it basically automates the paperwork so you can just focus on the art.
Exactly. It automates the intense legal compliance layer in minutes instead of days, weeks, or years. And it constantly updates with the newest state laws and union agreements, which really levels the playing field for everyone.
That is incredible. I mean, we started this deep dive talking about that terrifying 6 a.m. phone call from the distribution lawyer. And now, well, you know exactly how the underlying architecture works to ensure you never receive that call.
It's all about preparation.
Absolutely. But I want to leave you with a final thought to ponder as you step back onto the set. As platforms begin to seamlessly automate the intense legal and compliance side of making art, the barrier to entry is going to drop to zero.
Oh, definitely.
So in a world where everyone has access to the exact same AI tools, will the most successful filmmakers of the future be the ones with the best camera skills, or will they be the ones who are the most fluent in documenting their own humanity? Something to think about. Catch you on the next deep dive.